Hello, everyone, and welcome to Uncivil Law. For today's case, we have something dealing with your rights at the border checkpoints, and what Border Patrol can and cannot do to you as part of searching you. This is the case of Emmanuel Anglelo versus the United States Border Patrol. In this case, Emmanuel was trying to cross the border legally at a valid checkpoint, and then, some things happened which might be problematic, and the question is, can he sue for what the federal officers did to him? Let's discuss. At the time of the events at issue, Angelo was a 71-year-old U.S. citizen, a retired military veteran, and suffering from disabilities including cerebral myelopathy and impaired hearing. In 2016, while returning from a visit to Mexico, Angelo and a passenger were stopped by Brown, one of the Border Patrol officers, in one of the marked lanes at a port of entry. So he's traveling back from Mexico, traveling through a valid point of entry, and he's stopped for inspection as part of the Border Patrol process. Fine. About 5 minutes into the interaction, the officer placed a piece of paper on his windshield and gestured forward, directing him to a secondary inspection site for further examination. So some people, they want to examine a little bit more closely, and for whatever reason, the officer decided that he should be checked more thoroughly. Angelo pulled forward slightly, then abruptly stopped to verify that he had the opportunity to speak with his supervisor. Brown asked Angelo to shut off his vehicle and hand over his keys, and he complied. Two other officers, McChrystal and Guerrera, approached the vehicle from a secondary inspection area because they heard some yelling coming from the lane. So apparently they're getting into a bit of an argument now about whatever. So there's some yelling going on and some other officers are coming over to check out what's going on. So then what happens next is disputed. Angelo claims that McChrystal, without any warning, opened the door to the motor vehicle, grabbed him by the neck, and forcibly threw him to the ground and placed handcuffs on him with the assistance of another agent. The government argues that McChrystal asked Angelo to unlock the door and that they complied. McChrystal then opened the car door and asked him to exit the vehicle, which he did not comply to. McChrystal claims they attempted to help him from the vehicle, but when Angelo resisted, he used a shoulder pin restraint technique to remove him from the vehicle. Okay, so we have a bit of an argument about exactly what's going on, but either way, we have them going to the secondary inspection station. It looks like they kind of both agree that they were being asked to leave, and then one of them says, without really any warning, I was thrown to the ground. The other one says, no, I gave some warning, and then trying to pin him to the car. So there's a bit of a disagreement over exactly what happened, but this guy was not playing nice with Border Patrol as going through the border for some reason. The parties agree that once the officers and Angelo had reached the interior interrogation room, the handcuffs were removed, and Angelo was searched and interviewed by two supervisory officers. Angelo was released after questioning. The entire incident from the time Angelo first pulled into the primary inspection lane until he's seen on the video getting back into his van and leaving lasts just more than an hour. So the entire interaction that he had with the Border Patrol was about an hour as part of them determining whatever they were trying to determine. The district court converted the motion to dismiss the Bevins claims, because he brought Bevins as federal agents, into motions for qualified immunity, which it then granted. The district court found the claims for unreasonable seizure, false arrest, and false imprisonment failed because Angelo had not been arrested or unreasonably seized, and his claims for excessive force failed because Brown and McChrystal had not used unreasonable force. Okay, so the district court found that whatever else might have been happened, he was not actually arrested, even though handcuffs were put on him at one point, and he was moved from his car to some sort of facility for further questioning. So is that an arrest, or is it something else? We're going to have to get into it a little bit. Angelo argues on appeal that granting summary judgment based on qualified immunity of his unreasonable seizure claim was improper because he was either arrested without probable cause or at a minimum seized without reasonable suspicion. Qualified immunity shields federal and state officials from money damages unless a plaintiff pleads facts showing the official violates statutory or constitutional rights and there was clearly established right at the time of the challenged conduct. Qualified immunity shields liability from all but the plainly incompetent or those who knowingly violate the law. In order to make out a claim for unreasonable seizure, false arrest, or false imprisonment under the Fourth Amendment, Angelo must show that he was unreasonably seized. Although Angelo concedes that Border Patrol had the right to stop him at the border, he argues he was arrested without probable cause, or at a minimum seized without suspicion, when he was removed from the vehicle, handcuffed, and brought into passport control for questioning. Warrantless seizures are per se unreasonable unless they fall within a few narrowly defined exceptions, such as arrest with probable cause or temporary seizure based on a reasonable suspicion. Relevant here, however, one important exception is the border search doctrine. So the border like the home, is special, but kind of in the opposite way. So while a person's rights are paramount at the home, at the border, the government's rights are paramount. We have long recognized the government's plenary authority to conduct routine searches and seizures at the border without probable cause or warrant. As our colleagues in the Second Circuit have explained, a suspicionless search at the border is permissible under the Fourth Amendment so long as it is routine. Because the interaction took place at the border in the context of seeking entry to the United States, the government is entitled to conduct a routine search. Uncivil insists what he experienced amounted to arrest, not mere seizure for inspection. However, when the government has authority to stop or seize a person or property, the authority necessarily carries with it the right to use some degree of physical coercion or threat to effect it. Even outside the border context, using moderate force and applying handcuffs is not enough to convert a stop into arrest. And then they say, see example United States versus Sanders for more examples of what constitutes moderate force. Moderate force also apparently includes using force on a suspect, pointing a weapon at a suspect, ordering the suspect to lie to the ground, and handcuffing a suspect, whether singularly in combination. And that is not enough to constitute an arrest because it's moderate force, pointing a gun at somebody. Outstanding. Okay. In Sanders, for example, this court emphasized that handcuffs were merely a precaution in support of a reasonable detention. The handcuffs were briefly applied to a suspect resisting a lawful inspection and refusing to comply with reasonable commands necessary to carry out such an inspection. They were removed promptly once Angelo reached the interview room and he was frisked. In the border context, this interaction lacked the indicia sufficient to lead a reasonable person to believe they've been arrested. So a reasonable person would not believe that they've been arrested, being handcuffed, and being taken into a room to be interviewed. Okay. We therefore find that he was neither arrested nor unreasonably seized. The Supreme Court has explained that the reasonableness of particular force must be judged from the perspective of a reasonable officer on the scene, rather than 20/20 vision of hindsight. A use of force is more likely to be reasonable when officers use measured and ascending actions that correspond to a suspect's level of compliance or resistance. The context of our analysis is in the context of the international border crossing, where the government's interest in preventing entry of unwanted persons and effects is at its zenith. So the government has an interest in preventing the entry of unwanted persons. I'd like to tell some of my friends on the left about that. The government has an interest in preventing the entry of unwanted persons, but apparently they don't seem to know that for some reason. But there is a United States Supreme Court case that says that, so you know. The video of the incident shows McChrystal and Guerrero arriving to help Brown, after several minutes of Brown interacting calmly with a wild, gesticulating, and uncooperative Angelo. McChrystal speaks with Angelo briefly, then attempts to open the door. It is clearly locked, so he speaks with him again. He tries the door again and is unable to open it. He says something further to Angelo while pointing inside the window, and then successfully opens the door. He then speaks with Angelo for several seconds, apparently asking him to exit the vehicle. Angelo does not exit the vehicle. McChrystal briefly holds a hand out to Angelo, explained by McChrystal as an effort to help Angelo from the vehicle. Angelo neither accepts the proffered assistance nor exits on his own. McChrystal reaches in the vehicle with one arm. Angelo resists efforts to extract him from the vehicle with such force that the vehicle rocks from one side and the headlights flicker. Finally, McChrystal reaches in with both arms, wraps them around his midsection, and extracts him. McChrystal and Brown both testified that this was standard shoulder pin restraint technique that the officers used under such circumstances. McChrystal visibly did not grab him by the neck or throw him to the ground. In short, the video of the incident shows the officers using reasonable force to compel Angelo's compliance with the command they were legally entitled to give him, including by not arresting him, by putting him in handcuffs and taking him to an interrogation room. Angelo relies on Duval versus Marcinelli for the proposition that forcefully removing someone from their vehicle, if unnecessary, can constitute excessive force. However, the officers here had an indisputable right to inspect the vehicle, including by ordering him out of it. This also includes the implied right to use appropriate physical force to carry out the search if required. Because the officers did not use qualified immunity or did not use excessive force, they are entitled to qualified immunity. So the qualified immunity thing being a factor isn't particularly that surprising, but next comes perhaps a slightly more surprising thing, the issue of sovereign immunity. So this is like the top of the pyramid of immunity. We've got the qualified immunity, that's pretty good. Then we've got the absolute immunity, that's pretty good too. But then above that at the top is sovereign immunity, all the way at the top of the pyramid. We can't even sue them. So this is where this is going next. So even if qualified immunity wasn't an issue, we have the next issue where sovereign immunity. The agents are literally beyond the reach of civil law. Fun. Let's read more. Finally, Angelo argues that the custom duty exception to the Federal Tort Claim Act should not apply. Okay, so there's a Federal Tort Claim Act. The Federal Tort Claim Act says you can sue the federal government. And then it also says not so much in the context of customs. And so then he says, well, that exception shouldn't apply here. Okay. The Federal Tort Claim Act waives sovereign immunity for claims, quote, for injury or loss of property or personal injury or death caused by negligent or wrongful act of omission of any employee of the government while acting within the scope of his or her employment. So the government has waived sovereign immunity for injuries that the government does within the scope of employment, the torts. That's why it's the Federal Tort Act. However, under this custom duty exception, the waiver does not apply to any claim arising in respect to the assessment or collection of any tax or custom duty, or the detention of any goods, merchandise, or other property by any officer of custom or excise. I'd also like to take note here that this implicitly means that IRS agents can end your world, because that would presumably be a tax. So if the IRS agent shows up at your door, the IRS agent can make your day go really, really bad, and you can't do anything about it because they're exempt, baby. Yeah. When presented with this argument in the past, we've agreed with our colleagues in the Ninth Circuit that the law must be interpreted in a manner that reconciles the law without doing violence to any of it. As this court has explained, we agree with the Ninth Circuit that when strictly construed in the light of the law, the waiver of immunity only applies to tortious conduct not involving seizure and detention of goods by custom. So Custom and Border Patrol can do as they like, and presumably so can the IRS. So beware the tax man, beware the Border Patrol. For the foregoing reasons, the district court judgment is affirmed. Thus, that brings us to the end of the case of Emmanuel Angulo versus the United States Border Patrol. In this case, Emmanuel is a U.S. citizen crossing the border in his car from Mexico, and I don't know exactly what happened, but it didn't go super well. He was ordered over to secondary inspection, and he didn't want to get out of the car, and Border Patrol kind of roughed him up a little bit, and he sued. And he said, well, first of all, you were never under arrest, despite being put in handcuffs and taken to an interrogation room. That's not an arrest. Also, they had qualified immunity, and also they have sovereign immunity. So just basically all the immunity. So, don't do this at the border, I guess, is really the only takeaway from that lesson. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.